Hello, my name's Diane Dodds. I am an attorney in Kern County, and this is a workshop on the summary probate procedures available in California, and with specifically addressing Kern County. So just as an introduction here, the asterisks in the text mean that there are sample forms or additional information provided on the law library website. And then all judicial counsel forms, which are statewide forms, are identified by form number, and you can find those at this web address, the www.courts.ca.gov. And the best thing to do once you get your online there is to download the form to your computer and then save it and make changes to it from there. If you don't have access to a computer, you can come in the law library and use the computers there in order to fill out the forms. So this is being taped so that you can go back on the website and watch it again anytime you want. And it will be bookmarked so that if there's a particular topic that you're interested in, you can just go right to that topic. So the first question we ask when someone dies and we need to transfer their property is a probate procedure even necessary? Probate procedures are not required where there is a beneficiary designation, such as life insurance or retirement accounts. Typically on those, the deceased person's already filled out a form specifying who their beneficiaries are. If they did not fill out a beneficiary designation, then some kind of probate procedure will probably be necessary. But if they did have one, then it's just a matter of filling out the claim form from the company and sending in a certified death certificate. The other category where probate proceedings are not required is if the asset is held in joint tenancy. This is a sort of magic legal phrase that means that you held the property together with another person or persons, and it's when you take the title that way, that means it will automatically pass on death to the other people. So if you have a house that's in your father's name and your name as joint tenants, you don't have to go through probate. What you do is, for real property, a house or land, you will prepare an affidavit death of joint tenant, which is a form that's in your in the law library website packet, and then include a certified death certificate, and then you record that with the county recorder. If it's personal property, like say a bank account that says John and or Mary Smith, and the way it is recorded in the bank is joint tenants, then you just have to present a death certificate to the bank, okay? And then finally, if all you have to collect is a vehicle, a mobile home, or a boat, you can go to DMV for the vehicle or the boat, and to the Department of Housing and Community Development for the mobile home. And they have what they call non-probate forms that you can use to collect. So now, if you don't meet those exceptions and you think, uh-oh, there's going to be some probate proceeding required, first you have to know who's entitled to inherit. First you ask, is there a will? In California, generally speaking, a valid will has to be signed by two witnesses who watch the deceased person sign, and then signed as witnesses. Or it must be entirely in the handwriting of the deceased person. Now, there are exceptions to these rules, but they get pretty complicated. And if you would only have a valid will, if it as an exception to this, you're probably looking at doing a full probate, because that would have to be considered by the judge. Okay. So if there's no will, or your will doesn't meet the witnessing requirements, then the heirs entitled to inherit are determined according to what's called intestate succession. And that's just a fancy way of saying it's what the statute says is basically nearest next of kin. It's pretty much common sense what you would think. You know, if you're a single person and you don't have a will and you die, then your property will go to your parents. Okay. If you're your parents are deceased, it would go to your siblings and so on. The only complicated thing in California is because we have community property. So if there is a spouse, and if the property is considered community property, which is usually anything acquired during marriage, then it will pass 100% to the surviving spouse. If, however, it's considered separate property, and that's usually if it says right on the deed, it's separate property, or if or if the deceased person obtained it by gift or inheritance. If it's separate property, then it's going to depend on how many children there are. If there are 2 or more children, then the spouse gets 1/3 and the children share 2/3. If there's just one child, then they would split half and half with the spouse. So that gets a little bit complicated, but otherwise it's pretty straightforward. And there are, I provided in the law library packet of documents, you can access some charts that show intestate succession and family relationships, okay? All right, so if the only heir under the will or by intestate succession is a surviving spouse, then the spouse has special procedures available. There's an affidavit death of spouse, and there's a form for that in your packet. And there's a court petition, spousal property petition. The affidavit death of spouse really only works if the property, if your deed says right on it that it's the community property of the 2 owners, the husband and wife. And that's not common unless it says there's a way of holding title that is community property by right of survivorship. And then that will be very easy if that's what it says. Then it's just like you file an affidavit very similar to the affidavit death of joint tenant, and it passes to the survivor. But you can use an affidavit, just general death of spouse, if it does say it's community property. Okay. You have to include the legal description of the property and the assessor parcel number. It has the signature. The spouse needs to be notarized, and you have to attach certified death certificate and then record all this at the county recorder. If it doesn't say community property, then you're probably going to have to use the spousal property petition, which I will go into detail on later in the program. Okay, what are the procedures if the heirs are not a spouse? So first, for personal property. Personal property is everything except for land and buildings, okay, and mineral rights. Okay, so it's cash in the bank, it's furniture, it's uncashed checks made out to the decedent, it's contract rights. So it's really everything except for land and buildings. So if the entire estate that has to be collected is worth less than these threshold amounts, you can collect it very simply by affidavit. So the threshold amount that will qualify depends on the date of death. If the decedent died before April 1, 2022, then your limit is $166,250. If it's after April 1, 2022, the limit is $184,500. And if you're over those limits, then you will have to do a full probate administration. So for real property, you have two choices, depending on the value. And here again, it's going to depend on the date the decedent died. So if the death occurred before April 1, 2022, the limit is $55,425 and goes up to $61,500 if after April 1, 2022 for the affidavit re real property of small value. This is the easiest one to do. And so we'll cover that in a minute. The petition to determine succession to real property is a little more involved because it requires appearing before the judge and having a hearing. Those limits are the same as the personal property limits. It's either $166,250 or $184,500, depending on when the death occurred. And when you're adding up the value of the estate, you don't have to add in joint tenancy property because that you're already able to collect. So you're only going to add property that needs to be collected, all right? Okay, the affidavit for collection of personal property, there's not a state judicial council form, but there is a form that we provide that's in the packet you can download from the law library. You have to wait 40 days after death, and you have to include the notarized signatures of all the heirs or the beneficiaries, attach a certified death certificate. In this form, I don't think I have a picture of it here. Let's see, no. You'll see there's paragraph 6 has a place to describe the property you're going to collect. So it'll say the property to be collected is, and then it's bank account number XYZ at Wells Fargo or whatever the description is. And then at number 7, you list all the people entitled to inherit and what their shares are. So everybody who is a beneficiary has to be able to sign, okay? This would, unless the person has an agent under a power of attorney or a guardian or someone has been appointed to sign for them. And you just submit this packet to the bank or the insurance company or whatever it is, and they should issue you checks for the money. Okay, so now if it's real property, we have the two choices, the small value and then petition to determine succession. For all of the summary procedures of any kind, there's one thing that's often a little, that some people stumble over. all the successors have to be available to sign or their representative sign for them. And the affidavit has to cover all of the deceased person's interest in the property. So for instance, if you have like 4 children who are inheriting and 3 of them are all on the same page, but the 4th one says, oh, I'm not signing, I don't want anything to do with it. You're not going to be able to use the summary procedure. You will have to go through the full probate procedure. So it's only going to work if everybody's in agreement. The first thing that you do is to prepare your inventory and appraisal. That's because the court has to know that you meet those threshold maximum value numbers. And there's the state controller's office appoints specific people who are authorized to value property for estates in California. They're called probate referees. And so the probate referee has to be the one who values it, and the form is called an inventory and appraisal. So you do that first so you know what the value is and which procedure you're going to use. Then if it meets those lowest threshold numbers, you prepare the affidavit. You do have to wait 6 months after death to use the small value procedure, and then submit it to Superior Court with a filing fee of $45. So it's the cheapest, simplest out there. This is what the inventory and appraisal form looks like. And here I'm just going to take a minute to say, this is a judicial counsel form, and they're all laid out pretty much the same way. They almost all have a heading like this. And so up here at the top, you are going to put your name and address, phone number. Now, this is for the people that are inheriting. And if it's more than one, then just pick one who will be the official, receiving mail person. And you can put, say, John Jones, and then you can say, and others, or a little Latin phrase, et al, E-T-A-L. And then you put your name and your address and your phone number. Where it says attorney for, then you will just put either self-represented or there's a little Latin phrase, in pro per, P-R-O-P-E-R. Okay, then you have Superior Court of California, County of Kern. Now, Kern County is going to be the right county for you to file if one of 2 things. The deceased was a resident of Kern County when he or she died. Okay. If they're not, they were lived out of state but died owning property in Kern County. Okay. So in both those circumstances, Kern County is the right place. Now, let's say they were a resident of Riverside County, but they died owning property in Kern County. You're going to have to file this in Riverside. And you can still, the class is basically going to be the same. There's only the only difference is you're going to have to find out the address for the right court in Riverside, and you're going to have to use a Riverside County probate referee. So if you do qualify to file in Kern County, then you put in County of Kern, and then the street address is momentarily slipping my mind. It is, just a second. So it's 2100 College Avenue in Bakersfield, and the zip's 93305. And the branch name is Juvenile Justice Center, which I know doesn't make any sense, but that's where the probate court is. So it's not downtown in, you know, the big building on Truxton and Chester. Okay. Then under estate of, you give, what I like to do is the full name of the deceased person as it exists on the death certificate. So say it's Ralph Jack Jones. But let's say on the deed of the property that you need to transfer, it says R. Jack Jones. Okay. I would then, after the full name, put a comma and put AKA, also known as, and then put the name the way it is on the deed. Okay. So you want to list it both ways, the full death certificate way, and then the way it is on the property that you're trying to collect. Okay, then you're going to check the box decedent. You're going to check the box final, because you're saying this is all there is to collect. Then there's a box here. You're going to check property tax certificate, and I will go over that in a minute. You're required to file an assessor form with the county assessor when a person dies owning real property. Okay. For the affidavit of small value, if that's what you end up going for, you can't collect any personal property. It's only for the real property. If you end up doing a petition to determine succession, then you can also collect personal property. But usually it's much easier just to use the 13100 affidavit and collect it informally. That way you don't have to wait for the court. But if there's some reason, like maybe the person who has custody of the property is balking and won't honor your affidavit, then, and you need a court order, then if you're doing the petition to determine succession, you would have a personal property. Okay, so there's the total appraisal for attachment 1. That's where you're going to list the personal property, the cash, the furniture, if it is, whatever it is. Okay, and then you will have an attachment 2 that will list the real property. And then you are going to go down here, number 3, you're going to tell the court, this is all that you have to collect. Then you can just skip down to, you're going to tell the court, yes, I have satisfied law by filing the assessor form that we talked about up here. Okay, so when you have filed that with the assessor, then you check that box. Okay, then all the people who are inheriting have to sign this. Obviously, maybe if it's just 2 people, you can squeeze them in. If it's more than 2, obviously you're going to have a signature attachment. So you just get a sheet of paper and put signature attachment to inventory and appraisal. And then I like to copy this sentence, the I declare under penalty of perjury, etc., and then have a blank for, and then have the printed name, the date, and then a place for signature. In the summary procedures, you get to ignore this section about the bond because there's no bond in a summary procedure. Okay, so these are the written instructions that for what I just went over, okay, that you could go back and refer to later if you need to. Now we'll talk about the change in ownership statement, death of real property owner. This is the assessor form that you have to file. Here's where you can get it online. the form is BOE, Board of Equalization 502D. And it's pretty straightforward. It asks for the names of the people who are inheriting. You have to give the new address where the property tax bill will go. You enter the name of the decedent and date of death and answer the questions. As long as you have the APN number, the assessor parcel number from your property tax bill, you don't need to fill out any other information. And then disposition of real property, you check the appropriate box. If you're going to be going through some kind of probate procedure, court procedure, then it's going to be court order. Okay, in the transfer information section, you are going to check the box explaining who the property is transferred to, and then you'll determine if you need an additional form. Some people will qualify for a claim for exclusion from reassessment. The whole purpose of requiring this form is so the assessor knows, somebody died, now I get to reassess the property. Usually that means the property taxes will go up. There are limited circumstances where you can qualify for an exception for having your property reassessed. And it is for children, parents and children, and in limited cases, grandchildren. This exception used to be really broad. So anything that you inherited from your parents, you would qualify for an exclusion from reassessment. But that situation changed by Proposition 19, which was passed in 2020. And so here's another date that you have to know. If the deceased person died after February 15, 2021, then the only exclusion available is very limited. It's for the deceased person's residence, and it will only apply to if one of the qualifying children or grandchildren moves into and is going to be living in that house within a year of the death. Now, and the exclusion only exists as long as the qualifying child or grandchild is living there. If, however, and this happens a lot, if somebody died and no one did any of the probate work, if they died before February 15, 2021, then the old rules apply and you can apply for a claim for reassessment exclusion. So you're going to want to take care to see where you fall on the date and then make sure you're filling out the correct form. And these are all, like I say, available from the online. Okay. So you list on the main form, you're going to list the beneficiaries, their relationship, and only one heir beneficiary has to sign and date it, and then you need to take it or mail it to the assessor's office on Truxton. Okay, so you can read this over more later if you have questions of what kind of exclusion you might qualify for. So, but here I point out, if you're under the old rules prior to February 15, 2021, this is the form, the 58AH for children and 58G for grandchildren. Grandchildren only would qualify if their parent is deceased, okay? So for deaths afterward, the new forms are BOE 19P or 19G. All right, and they're also in the form packet that you can download from the law library. And then other questions, you can go to the assessor website. Okay, so we talked briefly about the attachments. If you're doing personal property, that's attachment 1. Most of you will just be doing the real property. It's attachment 2. And here at the top, you put the name of the decedent. Then you're going to list give a brief description of the property. Usually, like, let's say it's a vacant, unimproved. You would say unimproved real property located in blank city, blank Kern County. Described as, or if it's a house, I usually say single family residence located at, put the street address, and then say described as. And after the described as, you have to put in here the exact legal description in full, the way it is on the deed. So if you don't have a copy of your deed, you need to go to the Hall of Records and pick that up. What I tell people is a lot of times when you get your deed, you'll see it'll say transfer to so-and-so property described as, see Exhibit A. And then there's an Exhibit A attached that sometimes is quite long, several paragraphs. If that's the case, don't type it over. Make a photocopy of that description and kind of cut and paste it into the form, okay? Or say, or in your, if you say it was a home, see, be single family residence located at blank, blank street, blank city, California, described as, and then just say, see Exhibit A, and then have that photocopy of the Exhibit A. And the reason why I go over that is it's so easy to make a mistake retyping these legal descriptions, so that if that's even more than 2 or 3 lines, I would try to avoid doing it, because I have seen many cases where just an accident in the typing, and then the whole thing, you went through all that and thought it was all taken care of, it's not valid. All right. So you got to be very careful about that legal description. It has to exactly match the deed, and then what you put on here or on the exhibit has to match, if you're doing a petition, what's in your petition and what's in your order. Okay. So this is what I've already been over, you know, just make sure you have that complete legal description. Then at the end of the legal description, you put the assessor tax parcel number from your property tax bill. Okay, we have 2 probate referees in Kern County, and I will say this applies even if, let's say the property, you have somebody who was a resident of Kern County, but they owned property in LA County. Okay, you're still going to go to your local Kern County probate referee. Then they'll get in touch with the referee that's in Los Angeles. Okay, so you could pick either one of these. And if you are borderline, you're on the value. If you're thinking, gee, I don't know, I'm hoping I can do that really easy affidavit, but maybe my property's worth more than the limit. I don't know. Well, these probate referees are not paid very much for doing the appraising. They most likely will not be going to the property. They're going to maybe drive by, or they're going to maybe even just look at comparable sales in the neighborhood where the property is. So if other properties in that neighborhood are going for a lot more money, you will want to draw that to the attention of the probate referee and include a cover letter or email photos on giving any information affecting value, like for instance, the roof leaks, or the roof is caved in, or there was fire damage, or it needs all kinds of repairs, okay? Because that may help if you're in a borderline situation, qualify for the maximum value thresholds. Okay, here's what the Affidavit Re real property of small value looks like. And as I'd said before, you can find this form at courts.ca.gov. You also can download it from the Kern County Law Library's website. And so we already went over this. This is going to be the same in all the judicial council forms, that you have to put the name and then the location of the court, name of the decedent. All right. Then it's a pretty straightforward, put the decedent's name, they died on whatever the date was and then you put where they died. At least 6 months, you tell the court, yes, it's been 6 months since they died. And then here, you have to check how you qualify to be in the Kern County court. Either that the deceased person was domiciled, which means resident of the county when they died, or they weren't domiciled, weren't a resident of California at all, but they owned property in this county. Okay. Then you're telling the court you meet the value limits. If it's before 2022, 55,425, or after, it's 61,500. Then next is the legal description. So you're going to either type out or copy that a whole legal description from the deed, okay, and you put that as attachment 5 with the assessor parcel number. Then they ask, what was the decedent's interest in the property? If the decedent was the only owner, you just put 100%. Okay, if it was they owned it with someone else who still owns part of it, then you put whatever the percentage is. If the deceased person had a guardian or conservator, then you'll mark that box and put the information. Otherwise, you just say none. And when you file this, you have to include a copy of the original inventory and appraisal and original certified death certificate. Well, then you let the court know if there's no proceeding for administration of the decedent's estate, meaning there's no probate that's been opened. Okay, that's what will be in most cases. Or if there is a probate proceeding pending, then you have to get the consent of the personal representative for you to use this procedure. All right, now page 2, just put the name of the decedent there at the top. And number 9, the court is kind of just letting you know here, hey, you're responsible for all the debts of the deceased person up to the value of what the property that you're receiving. So kind of be on notice. Now you have to tell the court, how is it that you're entitled to inherit? Was there a will? Then you check that box and then you have to attach a copy. If there was no will, then you're saying that you're entitled based on the intestate succession laws and your family relationship to the deceased. Then everybody who's inheriting has to sign, type their name and then sign. And so you will need additional copies of this page to be filled out if people are, there are more people. And every signature has to be notarized. So you need as many copies of this page as you need, so that every signature is notarized here. And once you have all that, then, and these are just the directions I pretty much went through, you submit it to the court. If the deaths after April 1, 2022, there's an extra attachment, it's just a form. It's called DE 300, and all it does is set out what the maximum values are for small estates. So you just have to print it out and include it with your packet. Okay, that you don't write anything on that form, you just have to attach it. Okay, like I said, it's a big bargain. It's only $45. So you can go to the probate clerk's office and they have a window and you can drop it off, or you can mail it. Any way you do it, I advise making a copy, a photocopy yourself, so that you have that at home in case it somehow gets lost, okay? The probate clerk, if this doesn't go before the judge, by the way, the probate clerks are going to process this. And if they don't find anything that's a question, then they will send you a certified affidavit, all right? When you get it back and they say they've certified it, then you're going to take the affidavit, that's the basic judicial counsel form, any the legal description that's attached, and that's what you're going to record. You don't record the inventory and appraisal, and you don't record the death certificate, okay? Then you submit this to the recorder with another assessor form called Preliminary Change of Ownership Report, BOE 502A, which you can also get online, and it's really straightforward. It's just, you know, who the property is going to and who's going to get the tax statements. And then they go over possible exclusions you could have from reassessment, most of which are not going to apply. Okay. So let's say you got your inventory and appraisal back, but whoops, now it's more than the 61 whatever thousand. You don't meet the small estate value affidavit. You are going to have to use a petition to determine succession. Okay. Oh, and by the way, once you have this recorded, say finishing up on the affidavit, that is what you will have in lieu of a deed. It operates just like a deed. Okay. All right. The petition to determine succession, again, you have to have everybody who's inheriting an interest agree to participate in this process, okay? Everybody has to be in agreement, and you have to know where they are, right? So if somebody's missing and you can't find them, then you're not going to be able to use this procedure. You'll have to use a regular probate. So you should have already prepared your inventory and appraisal the way we went over, and your change in ownership form for the assessor. Okay, here with this petition, you don't have to wait 6 months. It's only 40 days. You prepare that and a notice of hearing, which I'll get to. And you can drop it off at the probate court, 2100 College Avenue, or you can mail it. Now, anything that you drop off or mail that has to do with this petition, you want to make 2 copies. One you keep at home so you know what you did. And then you give the court the original and an extra copy and a self-addressed stamped envelope so the clerk can mail it back to you, and they will stamp it, filed or received, with the date, and you'll have proof that it was filed in the court, okay? Otherwise, they're going to put it in a basket that's by the window, and unless you went there and checked all the time, or unless you checked online all the time, you won't even know that it's there. So there is a filing fee. It's $435. Now, if you are not able to pay $435, there is a fee waiver procedure that you can apply for. If you're on any kind of public assistance, it's usually pretty automatic that they will at least temporarily waive the fees. They are likely, however, when the property is passing to the family, then to require payment of the fees because you're receiving something of value, theoretically, that you could use to pay the filing fee. So this is what the form looks like. And like all the other judicial counsel forms, up here goes the name and address of the person inheriting, and then same information here for the court, County of Kern, and the address, and in state of the name of the decedent with any AKA that you need to. And then if you are also asking for personal property to be distributed, you would check this box. Most people probably won't. Then number one, the petitioner, now you list each person who's inheriting an interest, all right? And it says request a determination that the real property, and then check that box if it's also personal property, otherwise leave it blank. Described in item 11 is property passing to the petitioner. For decedent, you put the name, date of death, place of death, tell the court 40 days have passed since death, and then you tell the court how you're entitled to use the Kern County court, either decedent was a resident of Kern County or they were a resident. They weren't a resident of California, but they own property in Kern County. Then you check the box whether they died with a will, and then you would include a copy of the will. If they died without a will, that's called intestate, and you check that box. Then you tell the court either that there's no probate administration pending anywhere for this estate, or that the representative has consented to your filing this, and then you have to attach that consent. This is for California, okay. Regarding proceedings for estate administration outside the state, let's say somebody was a resident of Nevada when they died, you just tell the court either they have not commenced, meaning there's no probate going on there, or they have, and then if it's completed, you check the box and then give the information, the court and the case number. Okay, then now we come to the gross value part. This is where we have the according to the date of the decedent's death, and you check which it is. And then you're going to prepare your inventory and appraisal and label it attachment 8. Then you have these questions that are basically your family tree, all right? So you just got to make sure that you check every box that applies. So decedent is survived by, so it's 1 or 2, spouse or no spouse. If it's no spouse, then you have to check divorced or never married, or spouse deceased. Then it's 3 or 4. It's registered domestic partner. And if they did not have a registered domestic partner, then you check the box, no registered domestic partner. And then if there's a child, you check the box child, and then usually it'll be natural or adopted, but in rare cases, there's a natural child who was adopted by a third party. If there's no child, then you check the box, no child. Okay, then this question in 7, issue of a predeceased child. So that means the decedent had a child who died before the deceased person. And if that child had children of his or her own, then they are issue of a predeceased child. So then they would step into the position of the child. So let's say there's a family where there were 3 children, one's died, but the one who died had 2 children, okay? Then the way the estate will go is, this is without a will, it will be divided between 1/3 to each living child, and then each of the grandchildren from the deceased child will each get 1/6, okay? Okay, then you answered the question, decedent is or is not survived by a stepchild or a foster child who would have been adopted but for a legal barrier. This is very rare because there's a lot you would have to show about that legal barrier. But if you think it applies, then you're going to want to look at that probate code section. Okay, then you put the name of the decedent again up here. Now, number 10, you're only going to complete this if the decedent is survived by a spouse, but no children or grandchildren, or no spouse, no domestic partner, no children or grandchildren. Okay, so if they died with children, you're not going to fill out number 10. Okay. All right. Now let's say though they're survived by a spouse and no children, then you're going to check the first box that applies. Okay. They're survived by parents. If so, then you list them in item 14. Okay, if there were not survived by any parents, then sibling or issue of siblings. So it would be siblings or nieces and nephews. If there were none of them, then it's other persons who might be entitled to inherit the property if the decedent did not have a will. And you would list them. These are farther, like cousins, and list them on attachment 14, or no known next of kin. Okay. Then your attachment 11, that will have your full legal description of the property and what is the decedent's interest. If they were the only owner, it's 100%. And then if there wasn't a will and you're basing this on there's a spouse and it's important to know the character of the property, you will have to say whether it's community or separate or quasi-community property. Okay. This I don't know when that's going to come up in this kind of instance. So it's just going to be community or separate. So then you answer these questions that everybody who's claiming an interest in the property either was because of a will or because they are the intestate heirs by statute. And then the interest of each person claiming an interest. If it's real brief, it's say it's one person or it's 2 people, it's one person, then it would be 100% to that person. Or if it's 2 people, 50-50, you could put that in there. If it's anything more complicated, you're going to put it on attachment 13. And then number 14, this is going to be the names, the relationship, and the mailing address of all the people that you checked above in items 1, 9, and 10. So the reason we're doing this, is let's say there's a will and the will cuts everybody out but one child. Okay. You still have to list in the questions above, due to those, all the names and addresses of the other children, because they'll have a right to a notice of hearing on this, and they could possibly object if they thought there was something wrong with the will, for instance. So you don't forget to put when you're making that list for your attachment 14, the name and then the relationship, like child or brother or whatever it is. Okay, and then the age. If it's over 18, you can just put adult. Okay, if it's under 18, you will have to put the age and their residence or mailing address. Now, commonly what I do is because it'll make it easier for the court to understand it and follow it, is let's say there were the 3 children and one died before the decedent and left 2 children. So when you list the names and addresses, you're going to want to list the name of the deceased child and then just put their date of death. So this lets the court recreate with you the family tree. And because if you don't, they'll ask about it. So I'll just go ahead and put it on there. And then when you're putting their children on the list, then you would put grandchild, paren, child of deceased son, so-and-so. So then it's really clear in the family tree what you're talking about. All right, then if there is a will, you have to list all the people mentioned as executors. And if there is no will, you check the no will, or if there's no executor named in the will, you check that. Then if there was a trust designated in the will to receive the property, you check 16 and have to provide information about the trust. If the decedent had a guardianship or a conservatorship while they were alive, then you have to check this box and give information as on the guardian conservatorship. Okay, then you're gonna count all your pages, add 1 because you are going to make an index. There has to be an index for all the attachments. And the index, just you make it up yourself. There's no form for it. And you just put the name of the pleading and a brief description and how many pages it is. Okay. So then your number of pages attached will be, 2 usually for the petition, and then 1 for the index, and then however many you need for the attachments. Okay. All right, then just skip the part about the attorney, and then you have to put the date, the type name, and signature for everybody who's inheriting. So if it's more than 2 people, then you will need to make a signature attachment, right? Okay, and these were the instructions for how to do it. And here again, if the death occurred after April 1, 2022, you have to attach a copy of that DE 300 on the maximum values. And here is the notice of hearing, which you're going to fill out, same the top part, the way we've gone over it. And here, notice is given that, and here you put the name of the people who are inheriting. Whoops. And then it's fiduciary or representative capacity, if any. This usually won't apply, but let's say there was a deceased person or an incapacitated person, and so there's an executor or a power agent under a power of attorney. Then you would list those capacities. Then it's saying has filed a petition, and then where it says briefly describe, just put the name of it, petition for termination of succession to real property. Okay. And if you submitted this in paper and are getting a copy back from the court, they will fill in the date and the time, and the department is J1. That's where all the probate proceedings are heard in Kern County. All right, on the back side, fill the top part in, and then you are going to list down here in the numbered boxes all the people who are entitled to notice, and that's all the people that were listed on your attachment 14 and their addresses. And this is called proof of service. A person who is not one of the people who's inheriting, okay, has to mail a copy of this notice of hearing to all the people listed. And then when they do that, they have to fill this out under penalty of perjury for the court saying, yes, I mailed this. This is how I did it. I mailed it on this date, place, and whether or not they sent a copy of the petition with the notice. You don't have to, but sometimes if somebody's not expecting it, it helps, them understand why they're getting this notice. And then the person dates and prints their name and signs. And this has to be filed with the court 3 business days before the hearing. And don't wait around. Just as soon as you get it back from the court, go ahead and send it out and submit the proof of service so it's done. All right. Those are just written instructions. And like I said, the filing fee is $435. Don't forget if you're doing this by mail or dropping it off, include an extra copy, self-addressed stamped envelope. You can file it by e-filing, okay? And there's instructions sort of on the court website for that. E-filing does require your signing up with one of the companies that processes e-filing, and they will charge you a small amount, like $3 or something. I don't know what the going rate exactly is. But if you do use e-filing, then you do not have to send all the paper documents to the court. You're going to send PDFs over the computer. This is only for the petition to determine succession. For the affidavit for real property of small value, you have to file the original paper documents. Okay. All right. So now you have your hearing date. You can always go to kern.courts.ca.gov and where it's at, check case information and enter your case number, and it'll show you then all the documents that have been filed and what's been done in the case, and if there is a hearing scheduled. Okay. And if you're all ready to go and you have your hearing date, when the court has people called probate examiners who will examine all the paperwork for the judge before the hearing. And frequently they will have questions or find something missing or something they didn't understand. They need clarification on. What they will do will be to create probate notes. These will be little notes that will be at the bottom of the docket. And there'll be something like, oh, box blank or blank was not filled out, or need more information on predeceased child, or something, whatever it is. Okay. You want to start checking at least 10 days before the hearing date for the notes. If the court is in good form, they'll have those notes on there a week or more before the hearing. Sometimes They don't. They get behind, they can't do it. And you'll find notes the day of the hearing, or the day before, at which point, of course, it's too late to respond to them. But don't worry if it is too late to respond. You just go to the hearing and then say you need more time, and you'll get more time. But say you do have notes and you can get something on file. It has to be, to work, it should be at least 2 days before the hearing, but I'd try it anyway, even if you can't make that. You have to file a supplement, okay? And all that is, let's see where, I guess I don't have a picture of it, but I do have a form in your packet that you can download that I have. This is just a type form that I made up because there isn't a judicial counsel form, but it's just going to have the court heading similar to what's on the judicial counsel form. And then you're going to just address their notes, the same order they did, 1, 2, 3, 4, okay? And just either, if there needs to be a correction, saying, oh, I checked this box wrong, this other box should be checked, or whatever it is. If something's missing, you say, well, see, it's attached now to the supplement. So you just go through their list, and I already mentioned you had to file that original proof of service on the notice of hearing. Then when you, if you are going physically to the hearing, you will probably want to go ahead, and your probate notes are cleared. You will want to go ahead and draft the order, which I'll cover in a minute. And so I will tell you, the probate parking situation is very limited. And so you want to come early so you can make sure you find a parking place. You can also appear by Zoom and not have to go at all if you want. There, on the court website, there's remote hearings button, and you can check that and then follow the directions, and you can appear for free on Zoom. Okay, there's also a way you can do it on telephone, through court call, but that costs money unless you qualified for a fee waiver. But for no money, you can use the Zoom. So, and these are just more involved instructions. You just find Division J1 probate, and it'll tell you what to do. If other family members want to listen, there's an audio stream, they can listen. Okay, so let's say you had to file a supplement, and then you look back online the next day or so, and you see that it says the supplement was accepted and it's ready for hearing, meaning they've cleared the notes and now just going straight to the judge. So if that's the case, then okay, if you're going to appear in person, you can go ahead and prepare the order. If you're appearing on Zoom, you'll have to file the order after the hearing. But here's what the order looks like. It's another judicial counsel form. It's pretty straightforward. It just tracks what was in the petition about when the person died and who's inheriting and how much the property was worth, etc. And just the key things, make sure you've got everything listed properly about who's inheriting and what percentage. And if you have any attachments, which most likely you will, you check this box, signature follows last attachments. And then at the very last attachment at the bottom, you make just make a signature line for the judge, okay? And then you put the number of pages attached there. All right, when you have hopefully you will either have e-filed and then you'll see it, but if you haven't, if you did it by mail or in person, then you'll have your extra copy, and that's when you submit it, you submit, remember, the extra copy in the self-addressed stamped envelope, and they will mail you a copy of the order when it's done. So when you get that endorsed copy, you're going to make a request either in person or by mail for a certified copy, which is $40 plus 50 cents per page with your self-addressed stamped envelope. And then when it comes to you, your certified copy, you prepare a cover sheet. This is because there isn't enough space on the court forms for the recorder's office to put this whole sticky stamp thing. So you have to do the cover sheet yourself. I gave you examples, a sample in the form packet. And if it's somebody's home, a residence, then there's a little thing to check, and it's the recording fee is less money. After you get the certified order, you attach your cover sheet and you prepare the preliminary change of ownership report, just so the assessor knows where to send the tax bills coming. And then you record it at the recorder's office, and then you're done. That's like your deed, okay? All right. Now, the final procedure for summary is the spousal property petition. Okay, this is only going to work if only the spouse is inheriting. Now, sometimes you can still use it if the children sign off. So, for instance, there's property and it was separate property, and the kids technically have a legal interest, but they want mom to have it. Then if they sign an assignment of interest in estate to mom, then she will be the only one inheriting, and she can use the spousal property petition. I believe the assignment of interest in estates, another form I made up that that's in your packet. Okay. All right. So the top part's like all the judicial counsel forms, and you fill that in, and then this is going to be it's going to be spousal or domestic partner, depending on what the legal status of the relationship was. Then petitioner, this would be the name of the spouse or domestic partner. Now, whether you check A or B, this is going to depend on whether it's community or separate property. All right. And remember, we went over this. If generally community properties, everything that's acquired during marriage, except acquired by inheritance or gift. So if it's community property, then you're going to check both A and B, because A will be determining the property that's passing from the deceased spouse to the surviving spouse, and B is just confirming the 1/2 that the surviving spouse already owns as his or her community property. If it's only separate property, then you're just going to check box A. All right. And then petitioner is, and then you put what their status is. Usually it's just going to be surviving spouse. The date of death in number 3. Number 4, how you qualify to be in Kern County, and whether there was a will. If there is, you attach the will. And then we also give some family tree information, who survived the decedent, children, etc. Then only if there were no children, then you also fill out this information about a parents and or brother, sister, etc. then you're telling the court, okay, we don't need to have a full probate because this property is all just passing to the spouse. And there's two possible attachments here, 7A and 7B. 7A is the legal description of property passing from the deceased spouse, and that matching what we have up here, okay? If it's all separate property, then you're only going to have an attachment 7A. But if it's community property, you're going to have 7A and 7B, and they'll probably be exactly the same. And, you know, don't forget everything I said about the legal description having to be perfect. You do not have to have an inventory and appraisal, by the way, for a spousal property petition. So all the value limits don't apply. You could have $1 million piece of property and you can have it go through a spousal property petition. Okay. So you answer the question, did the spouses have some kind of written agreement about how to divide property? And usually it's no. And then number 9, this is going to be the names, relationships, age, and mailing address for all the people that family people you had to mention in the family tree questions, okay? And if there was a will, then everybody who's in there you have to list. And, you know, the executors, okay? And then if there was a trust, if the petitioner is a trustee of a trust that was under a will, then you have to give information and include the names and addresses of all the beneficiaries. And then you tell the court whether there is a petition for probate or administration of the estate being filed, or it was filed, or it's not been filed and is not being filed, okay, which is going to be usually the case. And then you can leave the attorney blank if you're doing this yourself, and then otherwise then the spouse will sign his or her name. Okay, you're going to need another additional attachment. If you read the fine print here, it says you have the legal descriptions are in 7A and 7B, okay? But then the reason why the property should pass or be confirmed to the surviving spouse are stated in attachment 7. All right, so what is attachment 7? You're going to have to make that up. And I don't have it on the slideshow, but I have a sample in the forms. And what you're really doing is explaining to the court how it is the community property or separate property. Let's say there's a deed and it just has the deceased name on it and nothing else. But he was married when it was purchased. Then you say, well, you know, they were married on X day and X place, and at the time the property was purchased, they give the date. They you know, were living together and married, and it was acquired from community funds, even though the name of the spouse didn't get put on the deed. And so you're, you know, explaining the history. Okay, if it's separate property, then there again, you have to explain, okay, is it passing because the will says it should all go to the spouse, or is it passing to the spouse because there's been assignment of interest in estate from the children? Okay, so here, you know, you list all those people that you had to mention in the family tree sections and will sections, and you list them and give their address. And those are all the people who are going to be entitled to notice a hearing. and the executors, and whether or not there's a trustee, and then, oh, I went over that information about it if there's a probate estate being administered. So here you probably also are going to need an index listing all the attachments. When you do your 7A, you know, this is for the community property. So you would say 50% is the interest passing from the deceased spouse, and then 50% is the interest that the surviving spouse already owns as community property. And so you just want to make sure you've had that down. That's 50% in each one, 7A and 7B. If it's separate property, then it'll just be 7A. It'll be 100%. Okay. Then you fill out a notice of hearing, just like I went over for the petition to determine succession, and you have to have it copy mailed by somebody who's not the spouse, not one of the children, okay, but can be anybody else, a neighbor or another relative, okay. And you have to, list all the people who are being served, and you have to give them 15 days notice before the hearing. I don't think I mentioned that before, but usually it's never going to be a problem because usually you're going to get a hearing date that's several months away. So you'll have plenty of time to get it mailed, but the minimum is 15 days. You file the original proof of service, then you go to the hearing, just like I said, you check for probate examiner notes, and you file a supplement if you need to, and then you prepare an order, which is just going to track your petition. Okay, let's see. We went over attending. And here again, you will want to, after, if you're doing it in person or by paper, by mail, you will send the order, and along with a self-addressed stamp envelope and a copy to mail back to you. When you get your copy, then you're going to request a certified copy, and that's what you're going to do a cover sheet for, and then record it in the recorder's office, just like we discussed for the others. So here's a little couple of extra things. If you have a will, okay, you will need to file it separate from your petition, the original will, because they keep original wills in a separate filing system. I'm not sure if this is true. They were letting you, if you filed it all together, they weren't charging you extra money for the original will, but I don't know if they're doing that or not, because there is supposed to be a $50 filing fee for an original will. Okay, if the original will was already filed at the time that you're doing your petition, make sure that you use a copy of it that shows the court's file number that they gave for the original will. Then in your will, if there's not this magic language above the witness's signatures that say that the witness is signing under penalty of perjury under the laws of the state of California, then you're going to need an additional form called proof of subscribing witness. If the will's done by an attorney, it will usually have that penalty of perjury language. But if it was self-done, sometimes they don't, then you need this proof of subscribing witness, which one of the witnesses has to testify that they were a witness and they did see the deceased person sign. If the original will is handwritten, then you have to attach additional form called proof of holographic instrument, another judicial counsel form. And you'll have to type up the whole will and then fill out the proof of holographic instrument. That will establish somebody who recognizes the handwriting of the deceased. Okay. General filing guidelines. That's how I told you you could, strike out attorney for and put in pro per. Here's the court address that I couldn't find at the beginning. Here. Just remember whatever you use to refer to the decedent in terms of their name, it should match on all the pleadings. And all the printed names should be consistent with the signatures. So you want to always identify the petitioners with the same names, and they always need to sign the same way. These judicial counsel forms, they can be printed two-sided if you want to, in which case they should be tumbled so that the back side is upside down, so then they can go in a flip file. But no worries, you can just print them on separate pages. You don't have to print them on the same page. But all documents need to be paper documents, obviously, 2-hole punched at the top. All attachments have to be labeled on the bottom with tabs on the original that hang down. You could just make a little piece of colored paper, identify it, attachment 11. If you're e-filing, obviously you're not going to be able to put labels on the attachments, but you will have to bookmark them. So you will have to have access to a PDF type program where it allows you to put bookmarks in. If you can't afford the filing fee, as I said before, I think you can fill out an application for a fee waiver, and that's their form numbers and order on a fee waiver. Okay. And don't forget, if you're submitting paper, always submit with a copy and a self-addressed stamped envelope so it can be returned to you. All right, common pleading problems. Double check to see that all relevant boxes are checked. This is very easy to overlook one. Make sure your legal description, your tax parcel number match on the petition, the affidavit, and the order, everywhere you have them. And make sure names and signatures match on the different pleadings. Make sure Kern County is the correct county to be in. Let's see. Don't go marking up the forms. You can always include an attachment if you need to explain something. And I think that's it. There we are at the end. I hope this was helpful.